good afternoon, everybody. Welcome to our Kelly Dry State AG webinar for the month, where we are featuring Hawaii this month. I started to say the Hawaii Attorney General, but it's more expansive than that, and you'll soon learn more. I also said good afternoon, but I should be saying good morning to our distinguished guests today. Really pleased to be joined by Mana Moriarty and Chris Leong, who are with the Office of Consumer Protection and the Attorney General, respectively, in Hawaii. And we're going to talk about the distinction between those two offices and how they interplay as we get into our topics today. Also really pleased to be joined by my colleagues, Abby Stemson, Beth Chun, Andrea Delormier, and who, along with me, round out our State Attorney General practice here at Kelly Dry. So with that, we will jump into this month's webinar. I'm going to start with a little bit of housekeeping for everybody, and then we will get into the topics for today. First, there will be questions that you can ask throughout the course of today's webinar. You should see the Q&A button in Zoom that you can use to type in your questions. We will monitor those. We may or may not be able to get to all of your questions today as we have this discussion, but if we can't, we will definitely reach out after the fact, or as those of you that have attended our webinars before know, we will follow this up with a blog post where we'll summarize what's discussed and then also answer any outstanding questions that we didn't get to today. Also, for those of you that are seeking CLE, I will be reading out a CLE code at some point during today's webinar. Once you hear that code, please make note of it. I will read it twice and only twice. And then you will insert that code into a form that we will provide that allows you to apply for CLE credit for today's webinar. So with that, if we can go to the next slide, we will quickly cover our agenda and then we'll get started. First, as I alluded to before, we're going to start by discussing these two independent offices in Hawaii and how they interplay and how they manage the consumer protection enforcement work within the state of Hawaii. Then we're going to do our traditional consumer protection lightning round, where we're going to go through some of the basics of Hawaii law and how it applies to consumer protection. And then finally, we're going to round out today with a discussion about the interplay between state and federal enforcement in Hawaii and some recent examples and issues that have arisen within the state. So with that, I'm going to hand it off to Abby to get us started on our discussion of the concurrent jurisdiction of the two Hawaii offices.
Well, thanks so much, Paul and Mana and Chris. Super happy to have you here today. This whole concurrent jurisdiction that you guys have in your state has perplexed me for many, many years. So I'm excited to be able to tell our viewers, for you to tell our viewers, how this relationship actually works. So what we're going to do is we're going to start out with Chris, who's going to talk about the AG's office. We're going to go to Mana, who is going to talk about the Office of Consumer Protection and obviously try to get a handle on who does what. So let's get started. Chris, first question, you work for the Attorney General, correct?
Yes.
Okay. How is the AG selected in your office?
So in Hawaii, by the state constitution and a few related statutes, the Attorney General is actually appointed by the governor. So the Attorney General is the chief legal officer of the state, but the Attorney General is also essentially the director of the Department of the Attorney General, which is one of the executive departments. So the AG is a member of the cabinet, like I said, appointed by the governor and subject to confirmation by the state Senate.
Okay. And so who is your current Attorney General?
So current Attorney General is Ann Lopez. She has been with us since, I think, technically the very end of 2022, but then was, formally confirmed in 2023.
And am I correct that Ann, or General Lopez, has been in the office before?
Yeah, she actually was. She had a stint in the office, I think around 12, 13 years ago, somewhere in that range, under then AG David Louis, where she was what we call the special assistant to the Attorney General. So working on special projects, legislation, things like that. And so she was here and she was in the front office, actually.
Very interesting. And I'm curious, with a new governor, do you typically get a new AG, or do some AGs stay through multiple governors?
Yeah, typically a new governor will bring in a new attorney general. You know, as I mentioned a minute ago, the governor has full and sole appointment power for the attorney general. So typically they will come in and take applications, you know, meet, interview people, and then, you know, appoint their selection.
Okay, and you said though then the Senate gets the opportunity to finalize that?
Exactly, yes.
Okay, very interesting. Thank you. So you have the area that Mana runs, which we're going to get into more, but tell us, what is your relationship with the Office of Consumer Protection?
Sure. So I guess the short answer is we have a good relationship with the Office of Consumer Protection, but of course, let me expand on that a bit. Like you said, and I echo, you know, I want to let Mana, you know, of course, speak about his office and what he does. But to explain it, you know, the Office of Consumer Protection is actually, or was established by statute. And it was created and placed within the Department of Commerce and Consumer Affairs, which is a separate executive department from the Department of the Attorney General. So Mana and his office actually, you know, report to the Department of Commerce and Consumer Affairs, and, you know, they don't fall under and they don't actually report to the Attorney General. So a lot of the work between his office and our office is actually really driven by relationship. And just to add really quickly there, you know, Mana actually, sorry, Mana, I'm going to divulge all of this, but before Mana was in the Office of Consumer Protection, he was actually in the Department of the Attorney General, and we actually worked in the same division together. So specifically right now, you know, myself being the new supervisor of our division in the Attorney General, and Mana being in the Office of Consumer Protection, and having the two of us who have worked together and know each other, actually makes it really easy for us to talk, you know, email each other when something comes up, pick up the phone and call. You know, that has made it very easy for us to collaborate and you know, work on things, talk on things when we need to.
Okay. And so let's talk more about the AG's office. So where does CP fit in the office?
Sure. So, okay, I'm going to apologize because this is going to be another slightly long answer. The division that I work in, which I think was on the title slide, is the Commerce and Economic Development Division. We frequently abbreviate it to CED, which hopefully you can see on the screen. CED is sort of a unique and sort of a broad division in our Attorney General's office. Our kind of primary responsibilities actually are advising and representing the State Department of Agriculture and Biosecurity, the State Department of Business, Economic Development and Tourism, and the State Department of Commerce and Consumer Affairs, which again is where Mana is located. We also house the CP consumer protection work. We also house the antitrust work. And then we also do sort of random things that might get assigned from the front office. And so within all of that, I have about 16 deputy attorneys general under me. And our CP, you know, resources are actually kind of limited. I have one, out of that 16, I have one deputy who mostly works full-time on consumer protection and some other assignments. I have a second attorney who mostly works on Department of Commerce and Consumer Affairs matters, and you know, has some of the position that can be dedicated to consumer protection. and then myself as supervisor to kind of oversee that. And then I may be able to ask people on a case-by-case basis for help when needed. So the actual kind of direct resources that we can devote to CP is on the smaller side in our office.
Very interesting. How about then, so because this other agency that we're going to learn more about in a second has a lot of the jurisdiction, how do you figure out what your duties and priorities are in regard to consumer protection?
Sure. So I think my just sort of initial general answer to that is, probably like in a lot of other states, a new AG comes in and they may have priorities and maybe interests or things they want to focus on if they can. So with AG Lopez, our current AG, she is really interested and concerned with focusing on and protecting youth in our state, in general, of course, but also as it applies to consumer protection. So that's a big issue for her constantly. Otherwise, we kind of take things as we get them or as they come up. So, of course, we may receive requests to participate in, multi-state investigations and litigation. I think we'll talk about that a little more later as well. Or other parties may bring matters to our attention, which we get asked to look at. So kind of a general answer there.
Well, thank you, Chris. Okay, so I'm going to turn it to Mana for a little bit, and then we'll come back to questions we probably have for both of you. So if we can, for the Office of the Consumer Protection, go to that slide. Okay, so Mana, you have a big title. You're the Executive Director of the Office of Consumer Protection. So how did you get that role?
I was appointed by the Director of the Department of Commerce and Consumer Affairs. Now, she, in turn, is statutorily designated as the Director of our office. So I serve at her pleasure. She is a cabinet member.
And cabinet member of the governor's team is what you're saying by that?
That's correct. She's appointed by the governor and also subject to advice and consent of the Senate. The state Senate.
Okay. And that's interesting. Oh, go ahead, Ma.
The director, it's an interesting relationship by statute. As executive director, I consider my role to be making sure the office is day-to-day functions are carried out appropriately, including the statutory duties. The director may, by statute, assume all the responsibilities that the executive director has. In fact, this position is not it's allowed by the director, but it is not necessary to have an executive director. Although throughout our history, we've always had an executive director responsible for the office's mission and direction.
Okay, and I'm curious, when she selected you, was there an application process or how did that work? Because I think prior to you, some of the folks listening, if you have been in this world, there was a gentleman named Steve Levins who was the executive director, I think right before you, right, Mana?
That's right. Yeah, Steve and I worked together closely when he was my predecessor at OCP, and I was at the Department of the Attorney General. Steve encouraged me to reach out to Director Ando directly. We did so, and pretty quickly figured out that this was a pretty happy arrangement, and we made it work.
Wonderful. So Mana, tell us, how is your office then organized?
We have two sections, legal and investigations. And these, we have 20 full-time employees, all of whom are dedicated to the office's consumer protection duties and functions. Pretty basic.
And remind us where the Office of Consumer fits. Like, there's a lot of other things going on in the department that you fall under, right?
That's right, Abby. The Office of Consumer Protection is one of 9 outward-facing divisions of the Department of Commerce and Consumer Affairs. Of the other 8, among them are the Insurance Division, the Division of Financial Institutions, the Professional Vocational Licensing Division, and the Regulated Industries Complaints Office, which serves as the enforcement arm for licensee matters. So our insurance commissioner, our banking commissioner are two of my colleagues, which I work with closely.
Okay, and how do you know what your duties and priorities are since you're the executive director? Do you have anything that tells you have to do X?
I do. I have the statute. I can look at our statute and know exactly what I'm required to do or what our office is required to do. We have a list of powers, duties, and functions established by the legislature in its wisdom. Our duties include investigating reported and suspected violations of laws enacted for consumer protection purposes by bringing civil actions. So we have the full panoply of civil enforcement authority in the consumer protection realm. Other duties include studying laws affecting consumers and recommending to the governor and the legislature laws in the interests of consumers. We maintain a clearinghouse of consumer complaints. We also are statutorily tasked with coordinating the consumer protection activities of all departments, divisions, and branches of state and county government concerned with consumer protection.
So, Mana, in that regard, can counties bring any actions under your consumer statutes, or is it just the Office of Consumer Protection and the AG's office?
Counties do not have the authority to bring consumer actions under our UDAP statute. They may bring other actions. For example, they may use other common law theories to bring an action, but they cannot bring a UDAP action in our state.
Okay. So Mana and Chris, what I'm hearing, if we compare Hawaii to other states, in addition to it being more beautiful maybe than a few states, it's lovely there, it also has some differences with the, so your AG is part of a cabinet and appointed by the governor. And for our listeners and those who have been in these webinars before, a lot of times it's a wholly separate constitutional office. So that seems to be one big difference. Also, we have the fact that not only do you have the AG's office that has jurisdiction, but you have an agency. And there's only a few other states that do that. Utah comes to mind, Wisconsin, any others that you guys can think of? South Carolina to a little degree.
You've hit the main ones. Does Georgia do something similar?
I think they may. And Tennessee also has one. But as far as I know, you have the most unique split of power, I guess. So
yeah, I think Abby, I think the closest might be Utah, which you mentioned. I think Maryland also has a separate office or division.
Okay. So if you're a business and you're watching this right now, you may want to reach out to the AG's office, and you might be thinking, well, in Hawaii, who do I reach out to if I have an issue, or maybe I want to explain a new product or service I have? So what would you tell businesses who maybe want to get in touch?
Chris, I could take this if you'd like.
Sure.
You can reach out to the Office of Consumer Protection, and you can reach out to me. But always, consider for a moment, right, that you've probably heard before that the agencies, are agencies of limited resources, and if you want to make a good impression, it's probably better to simply create no noise. If you're concerned with matters of compliance, we are not going to necessarily offer you advice on compliance. And yeah, I would say, consider carefully whether seeking a meeting is actually the right thing to do.
Good to hear that from you, Mana, because that is a big question for businesses at times. Should they reach out? Should they not? It sounds like something where, something to be considered here in Hawaii. Now, you mentioned multi-states, and I believe you've said you both have jurisdiction. So let's say there is a 40-state, multi-state. How is it determined who in Hawaii is going to handle this? The agency or the AG's office?
Well, when we talked before this, I kind of joked that we play stone, paper, scissors. But honestly, it does at times come to sort of, we're interested, are you interested? And just a conversation between Chris and I.
Mm-hmm.
Well, so your relationship is even more important than it sounds like, just on a personal level, because you have to get along, right?
Exactly.
Definitely. And Mana, how long were you in the AG's office before you became the ED?
I was in the AG's office 6 years.
Okay. So consumer has been your life for quite some time now.
That's right. I was the consumer protection person in the AG's office in Chris's division for that almost all of that time period.
So anything else you want to say about the relationship between the two? Or have we covered it all?
I thought you were taking this one, Chris. No, it's really it's a small state. We know what each other are doing, and we communicate effectively. And I think that's important for us to really have the greatest effect in the consumer protection field. We know we're both out there. We know we're a phone call away. And if we want to make things work, then we have to communicate regularly.
Thanks, Mana. Well, I think we'll move on unless Paul, Beth, Andrea, you have anything else to say on this topic?
Yeah,
right.
I think that was really informative.
So let's turn it over to Beth. We're going to go over our consumer protection lightning round.
Thanks, Abby. And so for those of you who have joined us before, you'll know that this is a section we do in most of our state AG webinars, where we try to ask a consistent set of questions to hear the variety of different answers that we get from different offices. And so we try to do it kind of at a rapid fire pace to make sure we can cover a lot of different ground. So to start with, here we've got an interesting situation where we've got potentially two different answers for some of these. So definitely, Mana and Chris, feel free to chime in as both of y'all as appropriate. We've gone over some of these questions here on the screen already about consumer protection priorities set in your offices, but I don't know if y'all have anything to add on that question.
Well, I was just going to say, see my answer from a few minutes ago. As far as priorities, like I said, it can be set by the individual AG. Otherwise, we're open to matters that come in, things we hear from multi-states or, other parties who bring a matter to our attention.
And for our part, enforcement and legislation absolutely are priorities. At the legislature, we are sort of one of the important voices, I think, for consumers. And in the absence of, sort of an interested nonprofit or private sector lobbyist, then we really have to be on top of the legislation that affects consumers. And I'm really proud of the work that we do in that area.
Can I ask a few follow-ups for that? Because that always fascinates me, especially with my background in Texas, where we had severe limitations on our ability to speak for or against any particular piece of legislation in front of our legislature. We were neutral resources for the legislature. We weren't ever advocating for or against. But it sounds like it's a little different in your role. And so I am curious to hear sort of, do you propose legislation? Do you advocate for specific legislation on behalf of consumers? How does that play out with your legislature?
Yes, we propose legislation from time to time, and yes, we advocate for legislation, introduced from other sources. It's very clear in our statute that is a key role of this office, and we serve as the voice of consumers. You mentioned express limitations on AG lobbying. Our statute is set up in such a way that it's not only are we not limited, we actually have the duty to perform that function.
Yeah, let me jump in, and I can add and kind of distinguish actually from what Mana's saying. Paul, I think my experience in the AG's office is a lot similar to what you said in asking this question. The AG's office, we are the attorneys for the state, essentially. So most of our time and attention is devoted to advising and representing the executive departments, but we do also advise the legislature when it comes to legislation and the legislative session. So we absolutely do not advocate for or against any bill. Actually, our role in that arena is to advise the legislature on legality of proposed legislation. Most of our testimony is pointing out potential issues with proposed bills, and ways to kind of fix them or correct them. But absolutely nothing on policy.
And we heard y'all talk earlier too about that you each participate in multi-state consumer investigations, sort of depending on the investigation. I don't know if you have anything else to add on that front that you'd like to talk about.
I don't think so, but the answer is yes, of course. We absolutely do participate.
Yeah. So as far as receiving consumer complaints, we've heard from Mana about that role as part of the OCP. I guess, is there anything else you want to elaborate on how that process works and the potential complaint resolution role?
We do play an informal complaint resolution role in appropriate circumstances. We may, reach out. We typically will reach out to the respondent and engage in a process of back and forth with the complainant and respondent in hopes that we will resolve something. But that the kinds of cases that are appropriate for that type of complaint resolution role are definite, and sometimes it's not appropriate for us to engage in that complaint resolution role.
Makes sense.
And then I'll add on to that a little bit, Beth. For our office, again, and this kind of goes to the more limited nature of our office, which is directed at advising and representing the state and state offices. So of course, like all attorney general offices, we have a portal for consumer complaints. People can write in, they can call the office, but on the flip side, we are actually limited in how we can respond and what we can say. We have statutory, essentially a prohibition on sort of advising individuals directly. So we can receive complaints, but often we look to refer them to the appropriate agency in the state, other agency in the state. So of course in CP, a lot of those we do end up sending to Mana's office because they can more directly respond to consumers.
Yeah, and that's pretty typical at AG's offices too. The fact that you can't provide individual advice, and it's sometimes very hard for consumers to understand why that could be the case. And same with why you can't always offer a complaint resolution role for every complaint as well. All right, turning to the next slide, please. Okay, so what is your primary consumer protection statute, or in this case, I think it was statutes? Who wants to take that one first?
I'll go ahead and take that. Our UDAP statute generally prohibits unfair and deceptive acts or practices in trade and commerce. It is a little FTC act, and I would consider that our primary consumer protection statute. We also have a Uniform Deceptive Trade Practices Act, which I would consider sort of a secondary consumer protection statute.
And do those statutes give you authority for pre-suit investigations?
Well, here our authority diverges somewhat. So, Chris, did you want to take that one?
Well, we have authority to conduct investigations, I guess, sort of generally, as the AG, as the AG's offices, as the AG's office. But then I'll turn it back to you, Mana, maybe for more, for your side.
Yeah, for the Office of Consumer Protection, we are not expressly authorized to issue a CID under our little FTC Act. We do, however, have full subpoena powers and investigative powers under our own enabling legislation, and that very effectively supplants, whatever authority is afforded under the CID statute to the Attorney General's office. So under our investigative powers, we can request documents, take statements, take examinations under oath, and we can compel the appearance of witnesses and compel the production of documents pursuant to an OCP investigation.
All right, so it's a little bit of a misnomer here to then ask the next question of, are CIDs confidential? Because it sounds like they're not technically CIDs, they're a special authority you have under your statute. But generally, I guess, are those requests themselves confidential, and what about the answers to those type of requests?
Absolutely, the answers are considered confidential. As for the requests themselves, I'm a little less sure, to be honest with you, and I'll just leave it at that. I'm sure somebody on my staff would know that better.
And in response to receiving those requests, is there the ability for a party to object or make a motion to set aside? And what kind of time frame would they have to do that in, if there is such authority?
Although our investigation statute does not expressly allow a party to object or to set aside a subpoena issued by the Office of Consumer Protection, courts have allowed parties to challenge our subpoenas in the same manner as a subpoena issued by the clerk of the circuit courts in a civil action. And in doing so, the courts have applied the same time frame and rules required for challenging subpoenas under the circuit court rules in a civil action.
So then it sounds like maybe that enforcing compliance may also be following general civil subpoena rules as well.
That's right. We initiate an enforcement of a subpoena action by filing a special proceeding, a petition for a special proceeding. But then from that point, the rules of civil procedure apply in that special proceeding.
Do your primary or secondary consumer protection statutes have a statute of limitations?
No, neither one does.
And under those statutes, do you have to provide pre-suit notice?
No.
All right, I think I'll turn it over to Andrea for some more of the rapid fire lightning round questions.
Yeah, so what types of settlements can you enter into?
Our office can enter into settlements, assurances of voluntary compliance, and consent judgments.
And what is your civil penalty authority?
Violations of Hawaii's UDAP statute are subject to mandatory civil penalties that are recoverable by our office or the AGs in a civil action. Violations can be counted per day or per violation, with more than one violation per day. So our appellate courts recently revisited that question and reaffirmed that an award of more than one civil penalty per day is authorized under our civil penalty statute.
That's interesting. Can you obtain restitution?
Yes, OCP can obtain both restitution and disgorgement.
And are there times where you don't get or seek injunctive relief?
There may be times when we don't get injunctive relief. Injunctive relief may be awarded pursuant to law. We have the authority, the express authority to obtain it. Going back real quickly to your question on restitution, our statute also allows our office to order to file an assignment of restitution in certain cases in which OCP obtains an award of restitution. But we have very rarely utilized that authority because, frankly, it seems almost unfair to make the consumer who was victimized by certain conduct responsible for going out and collecting their own restitution award.
Right, that makes sense. And then are there times where you don't get penalties or payments?
There may be, in a case of non-payment where the parties have already agreed to a payment, our office would file an action for breach of the settlement or an action to otherwise enforce the consent judgment or the AVC. So I guess that gets into your next question.
Yeah, that definitely relates to the next question. How are injunctive relief terms enforced?
Right. So in the situation where we have a consent judgment and the court has retained jurisdiction over a matter, we would go back to the court in which the judgment is filed. If we have an assurance of voluntary compliance, we may file an action to enforce the terms of the assurance of voluntary compliance.
And then switching gears a little bit, does Hawaii have any specific laws or remedies for auto renewals?
We do. We have a law addressing auto renewals that applies to a consumer contract that has a specified term of more than 1 month and an automatic renewal clause under which the contract will automatically renew for a specified term of more than 1 month unless the consumer cancels.
And does the law require any type of disclosures or anything?
It does. So the law requires clear and conspicuous disclosures informing the consumer of the auto renewal provision, how to cancel, and the deadline by which the consumer must cancel. A knowing violation of the law is a per se UDAP, which is subject to all of the remedies that we have available for UDAP violations.
And then is any kind of like advance notice required, like to consumers before the contract renews?
That's a good question. I'm not clear on that, but the deadline must be disclosed. So I would say that probably that provision takes the place of any, other requirement.
And then do you have any specific laws or remedies for price gouging?
We do. Our emergency powers statute makes price gouging during a declared state of emergency a per se unfair or deceptive act or practice. That statute is automatically invoked when the governor declares a state of emergency.
And under that statute, is there like a threshold for what types of price increases are prohibited, like an unreasonable price increase or unconscionable price increase, anything like that?
No, the statute works as a price freeze. So prices in effect immediately before the state of emergency is declared are, frozen, and any increase above the price freeze could constitute an actionable price gouging, misconduct.
And then rounding out the lightning round, does Hawaii have a comprehensive privacy law?
We do not. A comprehensive privacy bill has been introduced for a number of years now, but has not passed the Hawaii legislature.
Great.
So I think from here, we're going to turn to a broad topic. Really, as I said at the outset, we're going to talk some about the interplay between state and federal court in Hawaii, and in particular, sort of how you all proceed with consumer protection cases, in those courts. And, I know we're going to talk some about pleading standards. We'll talk some about remand removal. But I think it would be helpful, I'll sort of kick it over to you guys to sort of tee up this question, and maybe we can have a discussion about this interplay. It is a very interesting topic, and I think a fascinating one, and looking forward to hearing some about y'all's experiences, because it many times as ex-enforcers, I think there are a lot of considerations about whether you want to proceed in state or federal court. There are strategic decisions behind that, and there are obvious significant differences between, what you're going to face in state and federal court. So, I think it's a great topic, and look forward to discussing with you guys. So, I will turn it over to y'all to kind of kick us off, and we can kind of go from there.
Thanks, Paul. We thought this topic worth highlighting because there is tension. And it's interesting, and it's unclear to me, frankly, why the tension is there. Although we'll get to the reasons, and there may be, there are obviously considerations that the federal bench has adopted, and those considerations are at tension with the clear direction of the Hawaii Supreme Court. But let me start there. The Hawaii Supreme Court has clearly stated that Hawaii is a notice pleading jurisdiction. And to my knowledge, let me address that quote you see on the page. It comes from an Arthur Miller treatise, and it was adopted by the Hawaii Supreme Court in their latest decision, reaffirming that we're a notice pleading jurisdiction and expressly rejecting the plausibility pleading standard because, in their view, the plausibility pleading standard results in decreased access to the courts for citizens. So the Hawaii Supreme Court has again reaffirmed that the doors of the state courts are open to Hawaii citizens. And that applies to the state as well. In the UDAP context, it results in what I'll just say is a complete absence of any state court opinions applying the Rule 9b heightened pleading standard to UDAP claims, whether brought by state enforcers or by private individuals. So the state courts seemingly are very clear, and they have focused on the Rule 8a standard, the notice pleading standard, and they do not draw a direct line between an unfair or deceptive act in practice and common law fraud. I think there are good reasons for that, but we can get into that later. At the U.S. District Court for the District of Hawaii, and we only have one, there are a number of reported decisions applying Federal Rule of Civil Procedure, Rule 9b, to unfair or deceptive acts and practices claims, which the judges have characterized as claims grounded in or sounding in fraud. And the courts have focused, the federal courts in issuing these opinions have focused on Rule 9b's requirement that averments of fraud be pleaded with particularity. So I'll pause there.
And I guess sort of going back to this idea of, you know, the heightened pleading standard in federal court and their findings. I mean, do you find then, is there more of an effort on your part to stay in state court? You know, when considering, do I want to also raise a federal claim in a particular matter? Does that sort of weigh against bringing a federal claim because you don't want to get sucked into, you know, having your UDAP, having to plead a higher standard for UDAP as well?
I think that is a somewhat accurate characterization of our views on the matter. And we have been typically and consistently careful in drafting our pleadings in a manner that will make clear that our claims are founded on state law and not on federal law, and to otherwise ensure that any basis for removal jurisdiction is absent. You know, we've frankly had quite a bit of success with that careful, cautious approach to pleading. And we've had motions to remand granted in significant cases, which after remand to state court, you know, we feel led to some good outcomes. We had a number of cases, some of which are on your screen, in which the motion to remand was granted. For those of you paying close attention, the PBM misconduct case is both in the motion to remand granted and the motion to remand denied column. The first motion to remand was denied, and the second motion to remand was granted. So ultimately, the Department of the Attorney General responsible for bringing that suit was able to persuade the federal court after taking jurisdictional discovery that remand was warranted. This particular case involved a federal officer removal jurisdiction.
And do you find that there are greater efforts, I guess, from parties to try to remove you, even with your careful pleadings? Is there more of a desire to try to get you in federal court, you know, to take advantage? I mean, I guess, do you find that more defendants find that advantageous to them, and so they're trying to remove you into federal court?
I'm not sure I have a good basis for comparison to the efforts of the defendants in any other jurisdiction. You know, it's my sense that it's simply sort of the defense playbook for particular defendants to want to attempt removal. And it doesn't take a lot of familiarity with Hawaii consumer protection law to recognize that we have some some statutory law that is very favorable for consumers. We also have case law that is very favorable for consumers. You know, whether that motivates the defense more, I won't speculate, but you know, consistently in state court, the courts have been receptive to state enforcer consumer protection actions. And we do take that into consideration when we are determining and strategizing on where to file our lawsuits. I will say also, like, maybe somebody will play the devil's advocate here because there is temptation at the federal district court here to equate UDAP claims to fraud and require the pleading standards applicable to common law fraud claims to apply to UDAP claims. I, for one, find that problematic, particularly when it's just sort of adopted wholesale without any analysis. Fraud, as we know, requires scienter, and UDAP claims simply do not. Paul, you're nodding. Maybe you're willing to take up the other side of that argument.
No, I'm nodding because I agree with you. I mean, that is, I mean, I think that one of the factors we used to consider, you know, when I was at the AG's office was state courts know our state law. And when you go into state court in a UDAP case, they understand there is a totally different standard. They understand this isn't fraud. They understand too that the AG, or, you know, in your case, the OCP, are going to have a different burden than a private litigant. I mean, those are the kind of things that are definitely factors that, from an enforcer standpoint, you think about as, you know, you're deciding where and how you want to pursue a particular case. And I think one of the traps that you see sometimes defendants fall into is they immediately jump and assume, no, this is just common law fraud. This is the same kind of thing. And so, you know, I'll say that, like, from my experience, this is somewhat of a universal issue of ensuring that, you know, these differing standards don't bleed over into one another, because this is really the whole reason why there is a whole body of consumer protection law, as opposed to relying on common law fraud, is there are lower burdens, and, you know, the thresholds to get into court on this may be very different than what you have to prove in a fraud case. But you know, depending on where you are, a federal judge may have never taken up these cases before, and it could be sort of a new environment for them, and they may not appreciate that distinction.
Well said, Paul. Yeah, in our state courts, I would really encourage, you know, defendants to think twice about the authorities that they cite for the proposition that heightened pleading applies in a Hawaii state court, because those precedents, as far as I'm aware, would not be binding on any Hawaii state court.
So you mentioned federal officer removal with respect to the PBM cases. I'm curious, what else do you see out there as, you know, efforts to remove cases to federal court, even when you are trying to carefully plead in state court? Do you find that there are other avenues that defendants might use and have been unsuccessful on in trying to remove it into federal court?
We have a pretty convincing federal judge opinion rejecting the use of CAFA removal authority in one of our Attorney General enforcement actions, and distinguishing a class action that's removable under the federal Class Action Fairness Act statute from a state Attorney General enforcement action brought in state court under the state Attorney General's parens patriae authority to vindicate the interests of Hawaii consumers. So that was an interesting back and forth, and ultimately, you know, obviously our office was pleased with the result. I say our office, the state of Hawaii was pleased with the result in that particular situation.
And I know, you know, just again, from my experience, one of the things we saw at times were just straight diversity jurisdiction efforts where, you know, parties may attempt to remove a state as, you know, being a citizen of a different state than where the defendant is. But, you know, there is well-established case law that a state is not a citizen of any state. And so you cannot use diversity jurisdiction that way. And so those are the kind of things that, you know, I do think are just important to remember from a defendant's posture is that the state is going to be well versed on those kinds of tactics and has experienced that, and there are very different standards, again, applicable to the state as opposed to just a private litigant.
Well said.
So I know we've got a couple minutes left. I don't see that we've had any questions, but I'll just throw it to Abby, Beth, Andrea, if you guys have any final questions based on any of this discussion before we move to close things out.
Mana, I had a question because I know it's your office that receives consumer complaints. Any unique types of complaints that you've seen of recent?
We recently received a complaint, and this was from an out-of-state consumer, and he had gone to a big box retailer where he bought what he claimed were investment coins, or he may have even bought bullion. And he filed a complaint with his own attorney general's office, alleging that the retailer charged him state sales tax in violation of a separate state law which provided an exemption from state sales tax for any sales of bullion or investment coins. And this was a totally novel to me. I looked it up and since concluded that Hawaii does not have a law exempting sales of precious metals or bullion or investment coins from state sales tax. But I found that there was an effort, there was a bill introduced last year, and then sort of things, I refrained from jumping down the rabbit hole, but it's apparent that there are a number of states that have exemptions from state sales tax for sales of precious metals or investment coins. I think for those of you who work with e-commerce vendors or big box retailers, that's something that you would need to monitor, certainly, and be aware of in the states where your clients operate. We do consider, overcharges of state sales tax or that harm consumers as consumer protection matters, and our office has frequently investigated, and we wouldn't rule out bringing an action if somebody really dug in their heels and said, no, we collected the tax appropriately if there was an express exemption in place, or the state tax was misrepresented in some way.
Just to put a finer point on what Mana just said, one of my very first investigations that I led, and this will date me, was about inappropriately or applying sales tax incorrectly for dial-up internet services. And so, you're right. That is very much a consumer protection issue, and one that, is the kind of thing that can come up. And I think it's kind of a nice way to wrap up today, because it does underscore a point that I think we try to make on a lot of these conversations, that the breadth of what is covered in consumer protection, and especially when you talk about a state like this where you've got two independent agencies that are covering consumer protection, it can be massive, and it can go well beyond the kinds of issues that you just think about on a normal day-to-day basis, because UDAP laws are generally extremely broad, and they're meant to be broad to cover all of these different kinds of circumstances. And so it is really important in whatever industry you're in to fully appreciate and understand how broad that power is, and what the enforcers in those states are able to do with it. Mana, Chris, any last thoughts before we close things out here?
Not specifically, but I think in line with today's theme, hopefully, this was educational for people and getting a chance to see, our wacky state with its split concurrent authority. And I want to thank Mana for kind of delving into some of these issues here, I guess it would, it occurred to me that, in most states in the country, without this separate office structure, I think what Mana and his office does, would be within the Attorney General's office. So, we certainly have an interesting setup here.
And I just want to thank Paul and Abby and Beth and Andrea and their team who's worked on this presentation today and who's worked on this series. And thanks to Chris, who continues to be a valued partner in this important relationship.
Well, thank you both for taking the time and for sharing your insights today. We greatly appreciate it. We know all of our attendees appreciate it as well. And thank you to all the attendees today for participating. So with that, just a quick plug on the next slide to make sure that you've subscribed to our monthly newsletter, AG Chronicles, where we provide our insights into AG matters as they develop, and we highlight some of the topical AG issues as they emerge. And of course, we will be putting out a post that will end up in AG Chronicles about today's webinar. And finally, you can use our link tree to find out broader consumer protection news, advertising, privacy-related law. We have a slew of information on our website and a number of newsletters that you can sign up for. So one more time, just want to thank everybody for participating today and for attending, and we look forward to seeing you on our next webinar. Thanks, everybody.
Thank you.